Welcome to this module on forest conservation. In this module, we will try to understand what are the major forest laws in India and what are their key features and how these forest laws in India has evolved and what are the major role played by the Indian judiciary in shaping the forest law regime. So before we go into the substantive details of forest laws in India, let's try to understand why we need to discuss about forest. There are mainly three uses of forest. One, ecological, economical and cultural. Ecological in the sense that forest is an essential part of the ecology, and that whether it is for facilitating rainfall, whether it is for maintaining quality of the soil, or whether let it be the case of providing habitat for wildlife. The economical aspect of forest is that forest provides raw materials forest is an adobe of rich resources. It provides raw materials for several industrial purposes. So in that way, forests are extremely significant for economical activities. The third part is forests are not just significant for ecological or economical reasons, but it has some cultural dimension too, especially when we look at forest from a tribal point of view or traditional forest dwellers point of view. For example, it is part and parcel of their life too. And as far as the degree of forest is concerned, I mean ideally 1/3 of the total land area of the country should be under the forest cover. Now the question is, since we had already set a threshold called 1/3, what is the present scenario of forest cover in India? According to the Forest Survey of India, forest cover in India has been declining, and there are several reasons for it. Some of the major reasons are big development projects, mining activities, agriculture. For example, large part of forests are being removed for facilitating big development projects like big dams, and forests are being cleared for facilitating agriculture, or the diverse trees are being replaced by one kind of trees which are useful for industrial purposes. So there could be several other reasons, but the reality is forest cover in India has been declining, and it is in this context that we are discussing forest laws in India, as how this forest law regime contributes to mitigate these circumstances. And before going to the details, let's first have a mapping of what are the forest laws in its historical context. In India, we have long history of legal regulation of forest. So almost all standard textbooks or literature on forest laws in India goes back to the colonial period, where the colonial state introduced forest laws. So let's first look at the nature of those colonial laws, what kind of mechanism it envisaged to address issues relating to forest, whether it is for using forest or it is for protecting or conserving forest. Two important points in this regard is to understand about the colonial approach towards forest. The colonial government viewed forest as a source of raw material for several industries, mainly paper industries and railways. For example, they needed a lot of timber for construction for relating to railways, and forest was also drastically cleared for agriculture purposes. And different important forest laws includes Indian Forest Act 1865, Indian Forest Act 1878, Indian Forest Act 1927. Let's try to pinpoint some of the major features of this law, because these forest laws, these colonial forest laws, they introduced state control over forest. That means when they introduced state control over forest, the traditional forest communities were evicted from the forest, and these laws also facilitated exercise of monopoly over forest resources. It also facilitated monopoly over smelting industries. So altogether, the idea was to convert forests from public access to state control, and this also automatically resulted in the expulsion of traditional forest communities and tribals from forest, so that the state can exercise its monopoly. Now let us try to understand the major features of the Indian Forest Act 1927. Indian Forest Act 1927 introduced an interesting concept called reserved forest, the idea of reserved forest and the protected forest. This idea constitutes carving out of certain forest and notify it as reserved forest so that for better regulatory purposes. For example, it identifies and notifies certain forests as reserved forest. The moment it is notified as reserved forest, a number of legal regulation applies to that area. For example, prohibition of activities such as setting of fire, felling of trees, and even it also involves restriction on entry of people to that area. So to put in a different way, it involves removing or evicting all traditional communities residing in that forest, so that that forest become under the exclusive control of the state. And the rationale for these actions or these concepts mentioned in the Indian Forest Act 1927 were conservation of trees, preservation and improvement of soil, protection of water sources. By looking at this rationale and the idea of reserved forest, it sounds like the Indian Forest Act 1927 was enacted for the purpose of protecting trees or protecting the forest habitat. However, there are several criticisms of these laws. By looking at the Indian Forest Act in a holistic manner, there are several loopholes or several criticisms, and it does not really confirm to the previous statement that whether this Indian Forest Act 1927 was actually for the protection or preservation of the forest habitat. Some of these major points are: actually, Indian Forest Act 1927 sought to establish control and monopolize the use of forest. And the major idea was for the colonial state to earn income from the use of forest and forest producers. And this is quite evident from a number of other provisions in the Indian Forest Act. For example, look at the permit system as envisaged under the Indian Forest Act. The Indian Forest Act, even though they prohibits a number of activities, those are not absolute prohibitions. Many of these activities can be allowed provided the government permits it. That means essentially the Indian Forest Act 1927 introduces a permit system where many activities can be legalized with government permit, and similar activities can be criminalized if it is without government permit. So the idea was just for a better monitoring and to earn or to enhance the colonial government's income from the use of Indian forest use of the forests in India. So there are several other provisions which also reflects the economic angle of Indian Forest Act. For example, it has detailed provisions on levying duty on timbers, and it also has a detailed provision. It entrusts power with the state government to prescribe the channel of transportation of timbers. It also controls the channel of transportation. The idea is, the idea seems to be like the purpose of the law was to make it easy for the government to monitor and monitor all activities in the forest, and also to make it easy for the government to collect revenue. So let us try to summarize this critique of Indian Forest Act 1927, because what we can see is that 1927 Act paved the way for commercialization of forest in India, because it enabled the colonial state to exercise exclusive control over the government. To put it in a different way, it enabled the government to evict or to dissociate the traditional forest communities from their natural habitat. And it also helped, or it also facilitated this approach of viewing forest as a source of revenue and raw materials, rather than viewing forest as an essential part of the ecology that needs to be conserved and protected. And the result was large scale deforestation and deterioration of the forest habitat, because the years following all these Indian Forest Act, particularly the Forest Act 1927, what we had witnessed was a drastic deterioration of the forest habitat. Indian forests were cleared or destroyed for various industrial and other economic purposes, let it be for paper industries or for railway construction or for plantation purposes.